thanks very much for inviting me here to speak to you today. My name is Mairead Ashe. For my sins, I'm the Freedom of Information Officer and also the Data Protection Officer, amongst other things, with the Health Information and Quality Authority. I was asked to come here to speak to you today a bit about data protection and the common pitfalls that one stumbles across day to day. To speak a little bit to the legislation and what to expect coming down the tracks. So, in my mind, the kernel of data protection, it's about the protecting of the privacy of individual personal data. We can all get lost in the crowd, but we all have our own personal data that we hold dear to us, and that's the kernel of what data protection is about. So what is data protection? That's always the first question I get asked. So when an individual gives their personal data to an organisation or an individual, then there is a duty to keep that data private and safe. This process is known as data protection. The organisation or the individual who controls the content and the use of that personal data then becomes known as the data controller. So let's have a little think about what personal data is. Personal data means data relating to a living individual who is or can be identified either from the data or from the data in conjunction with other information that is in or likely to come into the possession of the data controller. So that's really important. And just a word of caution around that. In certain circumstances, the processing of data, which may appear on the face of it to be anonymous, and may allow researchers or even third parties who have access to the research datasets to identify individuals through what we call triangulation and the reconciliation of multiple sources. And this can happen inadvertently, and it becomes a data protection breach, and then you need to report that to the Data Protection Commissioner rapidly. So when developing any research project, it is advisable to consider the risks of de-anonymisation and the impact that will have on the individual's data and them. So not only do we talk about personal data, there's also what's known as sensitive personal data, and that data is defined under a number of different headings, and it ranges from race or ethnic origin down to the physical or mental condition of individuals, right down to other areas such as criminal involvement in proceedings or whatnot. So I've spoken a little about anonymisation. So what's the difference between anonymisation and pseudo-anonymisation? Well, in my mind, data is anonymised when an individual can no longer be identified from that data. So a data set that is linked coded, so names and other identifiers are removed, but which is linked to a separate file which is held by or accessible to the researcher, will enable the research subject to be identified. So that's really important, and it can include things like consent forms. That information is not anonymised. It's what's known as pseudo-anonymised information. So it's really important to understand these distinctions. So the law that underpins the whole data protection story in Ireland at the moment is the Data Protection Acts, the 1988 Act and the 2003 Act, which was transposed from the 1995 EU Directive. Now, it's really important to understand that the legislation contains very specific minimum requirements in terms of the processing, for example, of personal health information. And that's categorised as that very sensitive personal data that I alluded to earlier. Now, the legislation as it currently stands, it does envisage that sort of data controllers of, say, medical data would be allowed to process that information, and this processing does include research. So the current legislation is quite good. Some key responsibilities that you need to think about in relation to data protection. So from my mind, one of the most important things is that processing be undertaken by, say, a health professional or any other persons for that matter, must be done in a manner that protects the rights and the freedoms of the data subject. This can mean that the data can be anonymised, or that the subject of the data gives unambiguous, and it really has to be unambiguous consent to their data being used for very specific research purposes. The Act does provide exemption, the current Acts do provide exemption for processing for statistical, for research or scientific purposes, once carried out by the data controller, where no disclosure, and this is really important, where no disclosure of the personal data is given to an outside a third party. So what's the best practice? Well, it's really simple. Allow the data subject choice and provide them with the information in relation to how their data is going to be used. It should be standard approach to how you do your business. And why is data protection important? Well, very basically, to maintain public trust and confidence in your organisation. I mean, Irish Waters felt so foul of data protection that they just went through the floor with the trust element with the general public. And also, you need to protect the reputation of the organisation that you're representing. Excuse me. And also there are legal liabilities for your organisation in relation to not protecting data protection. And data protection is very much in the psyche of the individual. Every day you will see in the newspapers the headlines in relation to breaches of data protection, data protection issues, new guidances coming out, a whole plethora. It really does infiltrate the day-to-day of the individual, and it is very prevalent in their minds. And there's some very good surveys carried out by the Data Protection Commissioner, which you might want to look into, and it shows the percentiles of how dear people hold their own personal data and the use of that personal data. The Data Protection Act itself is a very nice piece of legislation as it currently stands. I'm not so sure as we move down the track what it's going to really look like, but at the moment it's broken up into 8 very nice, succinct classifications or principles. And very briefly, to process fairly and lawful the information that you're collecting, to obtain it for very specific and lawful purposes. The information that you collect, the data that you collect, it must be adequate, relevant, and not excessive. Now, I always underline excessive because we have a large inspectorate, and sometimes they can be quite zealous in the collection of data. I'll take just that, just in case. You really should not be collecting any more data than you need and that the data subject is aware of. And in certain circumstances, it's important that the information is kept accurate and up to date. Not to keep the information for any longer than is necessary is really also important, so there should be record management and record retention and destruction schedules involved in all of that. And process in accordance with the data subject's rights, so it's the individual's rights always must be at the forefront of what you're doing. And really, really importantly, keep the information secure. And then lastly, but very importantly as well, not to transfer that data into another jurisdiction where there isn't appropriate and similar data protection security in situ. So it's okay to transfer from EU country to EU country because they all have appropriate legislation in place. If you're transferring, say, to America, there's a safe harbour in place, so there are agreements in place for the transfer of data. But you really need to be careful about when you are transferring the information, where you're transferring it to, and that the appropriate security controls are in place. So I was asked to talk about pitfalls and that, and I was trying to scratch my head. So I've come up with a few questions, and I've tried to answer them. If I haven't asked the question here, please feel free to email me any stage. I'd be delighted to try and help out. Okay, so first question I always get asked is, what if I receive personal data for research purposes collected by a third party? Right, well, this is really important for you guys. It's in your interest and the interest of your organisation that the relationship between your organisation and the original data controller is very accurately characterised, and there is an appropriate agreement in place between the parties involved. Right, you really need to spell it out. The relationship really needs to be articulated, and get the your data protection officer to look at whatever that agreement that you've drawn up is, or if you don't have a data protection officer, then seek for legal advice. It really is important, because if anything goes wrong, the first thing the Data Protection Commissioner, Helen Dixon, is going to ask for is a copy of whatever agreement you have in place. So, what does processing mean? Is it just to do with computers? This is a question that I get asked a lot. So, no, processing is defined as obtaining, recording, holding data, or carrying out operations on the data. So if you do anything with the data, then that's data processing. So in real terms, so if you collect, you record, you organise, you store, you transmit, you adapt, you alter, you retrieve, you consult, you use, you align, you combine, you block, you erase, you destroy personal data, you are a processor. So the minute you touch a piece of information or data, you are a data processor. So should I tell data subjects about why I'm collecting their data? That's another good question. When you're collecting data from a research subject, it would be normal for you to tell people who you are, the name of the institute or the organisation that will be holding the data, what are you going to do with that information, who are you going to share it with. These are normal things that should be said. It's good practice to tell them about their rights to access their personal data. It's good practice to tell the organisation arrangements for holding secure that data. There should be no surprises. No one should be surprised by any potential use of their personal data by you, and you need to make it a point to explain it. Providing such information will be expected as part of any process of informed consent and for ethical purposes, and you must ensure that the information collected is used fairly. So it's really important. On our website, in the HIQA, www.hiqua.ie, we have a statement of information practice, and it may be something that you might look at, and it tells you all the information you need to know about how we are going to manage the general public's information that we collect en masse, and how to access that information, and under what legislative grounds we're collecting that information, and where to access that information, and who to make a complaint to if you have a problem with that. So, data obtained from a third party, what obligations do I have? Well, you need to understand where and when the data is was collected. You need to understand what information was provided to the original data subjects. You need to understand what the expectations of the data subjects are and how that data would be used. And you also need to understand the potential impact of the reuse of the data on the data subjects' rights and freedoms. And it's important for the data, it's also important that the research be looked at, and how that research will impact on the interests of the general public when you are taking third-party information. Now, I'm saying all of this, but you need to remember the Act does allow for this, so the current legislation does allow for this. So, another question that I get asked a lot is, am I supposed to keep my data up to date where necessary? Well, what does that mean? So, once research data has been collected, elements may become quickly out of date. The Data Protection Act requires that data be kept up to date where necessary, and the key word is where necessary. So the HIQA scenario is something slightly different from I think where you guys are coming from, but in general, research output will often be based on information that represents just a situation in a particular moment of time, and there'd be no reason to update that information, so you can get a get out of jail clause there. But you really do need to consider really if that data that you're collecting is going to be used to support measures or decisions about individuals in the long term. So if there's some sort of longitudinal study, you really do need to consider that. So there's some of the questions. The future, I'm really sorry to break the bad news to you, isn't so great when it comes to data protection and sort of the research element. Currently, there is a general data protection regulation under consideration. Now, it was supposed to come into effect March of this year, but it's still going through review and consideration. There was over, the last time I looked, 3,000 submissions in relation to the legislation. A large chunk of those came from the UK. Now, the new piece of regulation will supersede whatever is in place in all EU countries on the same day. And there's a number of new or more developed concepts within this piece of legislation. And the list is there: transparency about how information is being processed, right down to a very comprehensive liability schedule for data controllers, so there are large fines going to be imposed. One that I'm very anxious about in my role in HIQA is the right to be forgotten, and this comes from a social practitioners background, where individuals in the care of the state have rights around the removal of their data, and that is posing a lot of problems, especially for minors. Other elements which are being updated, reviewed, amended really significantly is the right to object to processing. And a good one for us all as citizens is the portability of our information. So it'll make moving from bank to bank or whatever, mortgages, a lot easier. The prevailing view currently is that within this new EU regulation, Article 81 and 83 of the data protection regulations, if they're taken forward, it will become a very heavy obstacle for you guys to overcome because of the specific consent that's required. I don't know how that's going to be got around, but there are a number of bodies. I think it's I'll just give it for a second. Made a note of it. The League of European Research Universities have made a very strong submission to the EU in relation to the research element, and they posed a large number of questions for consideration and amendments, and they're the strongest lobby group that I'm aware of in relation to the new regulations and the research element. So I'm sorry to end on that sad note, but thanks for listening. My email address is mash@hiqua.ie, and if I haven't answered any of your questions on that, I'm really happy to take any. I've also brought some booklets which I've left outside. There's this one which is on information governance, and it walks you through the good practice on information governance within the health arena and social arena, and there's a very good checklist that you can use, and you can access it on our website. It's a self-assessment tool in relation to information governance. And I've also brought along another book, and we've got lots of good guidance on data quality and data collection, and I've left a few of those outside. But again, if anybody wants copies of these documents, I'd be very happy to send them on to you. So with that, I'll keep quiet. Just to say as well that the Data Protection Commissioner has a very good guidance document as well on research and data protection, and it's worth a read if you're starting out.
Thank you very much. Any questions for Mairead? Please.
Just one question. You spoke about Articles 81 and 83 making research pretty much impossible.
Yeah.
But given that clinical trials are all governed by having detailed informed consent for every subject in the first place, why can that not be used to provide to obtain the specific consents needed? Why does it?
The threshold is very high, and this explicit consent notion that they have is it's really a high threshold, and for example, a lot of the researchers feel that they won't be able to meet the requirements that are being set down within the request for this explicit consent. So they're trying to lower the threshold back to somewhere where it becomes manageable.
So can you explain what you mean by threshold in that case? Because to me, consent is yes, I agree. So therefore, how is it difficult to get someone to say yes, I agree? What is changing? Yeah,
it's this full and explicit knowledge of every nuance of how the information is going to be used. Is what they were talking about. And that's the problem. Now, it's a draft regulation. There are huge problems with the whole piece of the regulation. As I said, there's huge concerns that even we as a regulator have with some parts of how it's constructed, and how hospitals are going to be able to function, how social workers are going to be able to function. So it's not just researchers, but from a research point of view, that threshold appears to be extremely high.
I think it may also affect hugely how you would pre-screen patients. So in order to identify the person, say who's diabetes, to ask them if they want to be in the study, you need to screen patients for diabetes. And the regulations may make that virtually impossible. So how you will go about identifying potential patients. People will have their privacy so well protected they can die from their diseases.
But the good news is there is a strong lobby that has made very good, strong submissions on behalf of researchers. Whether they'll be listened to or not is another thing.
Could I ask one very quick question? In clinical trials, we'll typically have an informed consent that we would keep the information for 15 years, or at least a minimum of 15 years, and we archive it in Iron Mountain and the rest of it. And there's a general trend, I think many people probably just plan on leaving it there indefinitely. But in keeping with the principle that you put of keeping it for no longer than necessary, presumably we should actually make sure that at the end of that period that is actually destroyed.
Yeah, you should have a record retention and management policy in place, and it should identify all of the records, how they are stored, where they are stored. So you may have some electronically, you may have some in hard copy, you may have slides, I don't know. There may be a myriad of different types of records that you hold, but you need to identify all of those records, identify how long it's appropriate legally or for whatever other reasons you determine, and then stick to that. Because if something goes wrong and the records aren't destroyed, you're in trouble with the Data Protection Commissioner.
Could I ask of the people, how many people actually do destroy their clinical trial records after 15 years?
I'd just be very concerned. I'd be very concerned about all this. A recent trial presented at the AHA was WASCOP's, West of Scotland Coronary Prevention Study, performed in the 1980s, and they followed their data 25 years later. And those who took a drug for 5 years had maintained the benefit, whether they were on it or not, an additional 20 years later. So I'm afraid we might be throwing the baby out with the bathwater if we go ahead with these proposals.
But the key thing is you're determining, if it's not legally imposed on you, how long you keep the record. So you, as the practitioners, will understand. Like in HIQA, it's very easy. In a corporate entity, you keep HR records for so many years. You keep your financial records under legal guidance for 6 years plus one. In our registration process, it's legally required that we keep our records for the cycle of a registration. So that's 3 years plus one to allow for any overlaps. So where there is an absence of legislation, ye are the practitioners, ye will understand how long the record should be maintained for. You need to document that. You need to manage the records. So it's part of good record management.
Are there any other questions? Sorry, please at the back.
It just links into what Joel said there about keeping records indefinitely. So if you're managing and collecting and storing trial records and you register as a data controller, should you register every year forever, as long as, or up to the point of you destroy them, or is there any guidelines around how long you need to keep your registration up as a data controller for a particular study line?
Well, we defined what a data controller is, so when you fall outside of that definition, then you don't need to register. Yeah.
Any other final questions? Thank you very much.
You're welcome.